Merseite Convention. In its submission in this respect, Applicant relied on the rebus extantibus rule as a justification of its repudiation of the Convention. Before assessing the criteria for invocation and the fact that they were not met in the present case, the respondent would like to remind this court that the rebus extantibus rule has never been applied by the International Court of Justice. The decision of the European Court of Justice in the Ragi Genbacha versus Hauptzollamt Mainz case has two main drawbacks.
The fact that you reminded us of this, first of all, thank you. But second of all, why is that important? Why is it important for us to know?
Your Excellency, as this court stated in the Countermeasures case decision, the negative formulation of the customary rule of rebus extantibus leads us to the fact that it should be accepted in exceptional cases and that the criteria for their assessment of this rule should be interpreted as narrowly as possible. As regards the decision of the European Court of Justice, in that case, it was mere a review of the decision of the European Council, and in stating that the rebus extantibus rule was applied, the European Court of Justice stated that the Council did not make a manifest error in applying, but did not say that it was right to apply. Moreover, Your Excellency, in that case, Yugoslavia did not object to the invocation of the rebus extantibus rule, which is completely different from our case, when the respondent argues that the rebus extantibus rule cannot be applied.
Even in these circumstances, Council, do you challenge that the rebus extantibus is a customary international principle?
No, Your Excellency.
Thus we could apply this?
No, not in any event, Your Excellency. In assessing the criteria of the rebus...
So you think that it is customary?
It is customary, Your Excellency. It was recognized by this honorable court. So, Your Excellency, in assessing the criteria of invocation of the rebus extantibus rule, the respondent relies on the Article 62 of the Vienna Convention on the Law of Treaties, since it was recognized as a codification of existing customary rule in this regard in the fishery jurisdiction case and in the Gabčík-Marš case. There are two cumulative criteria which would justify the invocation of the rebus extantibus rule. The first one is that the circumstance it changed should have formed the essential basis of the parties' consent to be bound by the treaty. The second criterion is that this change should have transformed the extent of obligations still to be performed. However, neither of these two cumulative criteria is applicable in the present case.
Well, the argue with respect to the second one, that's really, I think, I'd like to hear on right now. They argue that the quantity of the extraction of the material minus the change in their obligation. What do you say about that?
Your Excellency, in assessing these criteria, due care to the provisions of the Merseite Convention should be taken into consideration. According to Article 4, the Reverentian Merseite Trust, the Reverentian state-owned company, had the right to sell the Merseite abroad, and the parties provided for the possibility that this resource can be sold abroad, and that there were no limitations on the price, so the parties recognized that it can be marketed. In the present case, the mere change in the medical science underlying this treaty and the increase in demand worldwide did not transform the extent of obligations still to be performed by Agnostica.
Well, they're saying that it is because it's actually a very similar argument that your co-agent applied just in a different circumstance, right? It's a matter of gravity and it's a matter of extent. Everything in law is a matter of extent. So what their argument is, yeah, you can take some materials out, but once it changes fundamentally the amounts that you're now extracting, that changes fundamentally the application. So yes, you're correct, that may have been contemplated, but if you go from 100% to 300% or what's not, now you're dealing with a different nature of the obligation.
Yes, Your Excellency. However, in the present case, the change of commercial value is the commercial risk with the parties undertook when entering into the Merseite Convention. It should be taken into consideration the fact that Agnostica did benefit from the
Was it actually, this convention, did it actually intend to regulate those commercial risks, business issues, or it was rather the intention was different?
Your Excellency, the parties did entail the commercial risks since they provided for the possibility to adjust the price in which the Merseite should be sold. They also provided for the possibility to sell this resource abroad.
Indication what kind of regulation applied?
You mean, what, you mean?
I mean, inflation, something. cost of labor, foreign exchange rate.
Excellency, this has all the risk which should be taken into consideration. And when the commercial value increased, the Agnostica, the applicant state, which received the annual royalty of 10%, has also received more amount of money. And the quite similar circumstances were considered by the EC Tribunal in the cases of Perenco Ecuador Incorporated versus Ecuador, where the state wanted to terminate the concession agreement on the basis of the increase in oil prices. However, the notion, and the claim was based on rebus extendibus rule. However, the notion of rebus extendibus was completely denied, since the Ecuador was the state which benefited from the higher oil prices.
But are you trying to get us to read that in? Because there's no explicit requirement. Essentially what you're saying is they have benefited, they're going to continue benefiting proportionally. So are you trying to ask us to read in an additional element that's not part of it now?
No, Your Excellency. As this court held in the fisheries jurisdiction case, in order to meet the criterion of the transform extent of obligations, these obligations should become excessively burdensome or unreasonable. And what the respondent proves in this case is that the further application of the Marseille Convention was not so burdensome, since the applicant also benefited from this.
But did the applicant actually refer to the increase of price?
No, Your Excellency. And this is the basis of the first argument of the respondent state. The applicant invoked the change in medical science and the increase in commercial value, the fundamental change. However,
that's something that lacked in this case, correct? The oil intended to...
No, Your Excellency, it was not the part of medical, traditional medicine or the cultural significance. However,
Distinction without a difference. It's a distinction without a difference, is what you're saying, okay?
What is important in the present case is that the essential basis of the parties to enter into this agreement was the desire to supply this resource to those for whom it holds cultural significance. In the preamble of the convention to which the applicant relied, it is expressly stated that the parties entered into the Marseille Convention in order to, while recognizing the ancient traditions, recognizing the significance of this resource to traditional medicine, and wishing to ensure this resource to those for whom it holds cultural significance. Namely, the essential basis of the parties to enter into this agreement was the reliance on traditions and culture, and the mere change in commercial value or medical properties did not change the object of this agreement to supply this resource to those for whom it holds cultural significance. And on this basis, the Marseille Convention still should be applied, since the demand of local practitioners is satisfied, and since the life-sustaining resource is supplied to international pharmaceutical companies by Revenge and Marseille Trust in complete compliance with the provisions of the Marseille Convention. And the applicant did not dispute that, in fact, RMT could have violated the provisions of this agreement.
According to what you say, according to the object and purpose why the convention was concluded at the beginning of the century, isn't it that the international medical discoveries actually absolutely turned the idea of the commission upside down? So the applicant state never had this, never could have foreseen how the development of medicine would go on. So from that respect, the applicants argued at some point the principle of foreseeability. How would you reconcile with this? Isn't it that actually this resource, which is their resource, could be a very important resource for their country?
Your Excellency, the respondent does not dispute the fact that Marseille is of significance for Agnostica. It doesn't dispute the fact that there was a change. It doesn't dispute the fact that it was unforeseen. However, in order to justify the invocation of the rebus extendibus rule, two cumulative criteria, which were already referred by the respondent, should be met, and they are not met in the present case, which means that the convention cannot be terminated.
Isn't it that there is a principle of sovereignty of the natural resources?
Your Excellency, there is a principle, and we do not dispute it. However, when relying...
What is the legal status of this principle?
Your Excellency, this is the Customary international law.
Just?
Was
according to what gives you the authority to claim customary law?
Your Excellency, there were some judicial decisions in which this rule was...
How do we establish a customary law?
Your Excellency, the Customary international rule, as this was stated in the North Sea Continental Shelf case and Nicaragua cases, comprises of the opinion juries and the state practice, and when these two criteria are met, the birth of the customary rule is established. And when relying on the General Assembly Resolution 1803 of 14th December 1962, the applicant tried to invoke its permanent sovereignty of natural resources.
What would be the relevance of General Assembly Resolution to Customary?
Your Excellency, it may be regarded as the opinion juris, since in adopting the resolution, and it was adopted unanimously or quite unanimously, or majority of states voted for it, it can be regarded as the opinion juris for the purpose of establishing the rule. However, the addressing of the issue, the principle of permanent sovereignty does not dispute the fact that the treaty should be complied with, and it is expressly stated in the Declaration of Permanent Sovereignty that those agreements which were freely entered into should be complied with in good faith. Your Excellency, in relying on the rebus extendibus rule, the applicant also failed to prove that the procedural requirement of the invocation of this rule were met. The significance of these requirements was upheld by the International Court of Justice in the Shevchenko decision, where it stated that the Articles 65 to 67 constitute the generally reflect customary international law, are based on the obligation to act in good faith.
Under international treaty law, when you're talking about the custom, is a procedural requirement customary as well? Or is it just a material rule as such?
It may be regarded, since the essence of the procedural requirement is to ensure that there would be no abrogation, there would be no unilateral assessment which could lead to unreasonable application of the rule. And in the present case, the applicant did attempt to negotiate, well, it did not attempt to negotiate.
But what is this procedural requirement? Some kind of notification, correct?
Your Excellency, there should be a notification of the party which wants to invoke the rebus extendibus rule, for instance. It also applies to material breach.
But here we have a proposal to terminate.
Your Excellency, the proposal to terminate does not constitute a notification of the amount.
But we will not notify it, effectively.
We were proposed to terminate the Marseille Convention on mutual consent. There was no indication that the parties relies exactly on the rebus extendibus rule. Moreover, Your Excellency,
but they did mention
the change in science underlying the treaty, Your Excellency. Fundamental change.
Sounds pretty similar. And once we don't have like BCLT in place.
Your Excellency, in any event, there should be a period of the period which follows after this notification.
When was this proposal? Can you give us the date?
The 2nd February 2012. 1st February, yes, Your Excellency.
Okay, but let's say we'll agree with you and we'll say, you know what, fine. They have not met the notification requirement. What do you want as a remedy? You want it back for enforce in effect? You have it back for enforce in effect. They'll notify you and we'll be back in court. Right?
Okay, we'll meet next
so we'll relitigate it, waste our time all over again.
We will do this again and we'll prove that. Could you please clarify your question?
No, you're saying they have violated procedural, and listen, I understand procedure, and you know, but once again, dying on certain hills. So fine, let's say we rule in your favor the fact that they've breached this technical procedural requirement, and we'll give you a remedy of declaring this convention again to be a force in effect. They will come back, they'll notify you properly, and then we'll be back in court on the same substantive issue. So really, is it something we want to...
No, Your Excellency, provided that no circumstance which could meet the requirement of invocation of rebus extendibus rule arises, there would be no attempt to rely on this rule again.
Are you aware of any decision, of our decision with regard to the lack of procedural, well, not with regard to rebus extendibus, but generally, when the procedural rule has been considered to be violated, and the case in, for instance, Countermeasures?
Not at the moment, Your Excellency. Thank you. So, turning now to the second submission of the applicant, of the respondent in this case, namely that the Marseille Convention was not terminated on the 2nd April 2012, and that by unilateral withdrawing from this agreement, the Agnostica constituted the repudiation of the treaty. The respondent reacted accordingly and resorted to countermeasures. Should this court find that the Marseille Convention was terminated on 2nd April 2012, it would result in the fact that Reverentia did not violate any international obligation, since it would no longer bound by Article 1 of the Marseille Convention, under which it is under obligation to provide technology. In the present case, applicant stated that by removing the software, the proprietary right of Agnostica to the facility was violated. And in order to establish where there is a right, the Merseyside Convention should be interpreted through application of the general rule of interpretation. In the present case, the applicant does not dispute the fact that due to evolutionary principle of interpretation, the term technology should also include the notion of the software, and in this regard, respondent agrees with the applicant. However, what is important is that Article 1 and 2 of the Merseyside Convention provide for virtually two different regimes for the notion of facility and for the notion of technology. It is stated in Article 2 that the ownership right to the facility was transferred upon payment of the 100 Swiss franc, and the respondent does not dispute the ownership right of the Agnostica to the facilities. However, what is important that under Article 1, respondent was under obligation to provide technology. The ordinary meaning of the term provide is to
But Council, in the countermeasures regime violates the rules concerning facilities?
Your Excellency, the notion of countermeasure is by itself an international wrongful act, and we do not dispute that should this convention... Yes, it is, Your Excellency, but the wrongfulness thereof is justified by the mere nature of the countermeasure.
What is the basis of the description?
The rules regarding the countermeasures are enshrined in articles on state responsibility for international wrongful act, and they were expressly relied when assessing the countermeasures notion, for instance, in the Shevchenko case decision. Your Excellency, the respondent does not dispute that if this convention is enforced and is enforced, the removal of the software could have violated the obligation of the respondent to provide technology. But the wrongfulness of this act is precluded by the notion of countermeasures, which is a legal reply to the repudiation of the convention. In order to be justified, there are several cumulative criteria for invocation of the countermeasures. Namely, they should be addressed against the state which is responsible for international wrongful act. They should be temporary, reversible. Their aim should be to induce the state to again be bound by the provisions of the convention, and they should be proportionate. All of these criteria are met in the present case. The removal of the software took place in response to the repudiation of the Merseyside Convention. It is expressly stated, for instance, by the President of Reverentia and by Vice President, that such removal would last until Agnostica again respects its international obligation. And it was also mentioned by the Vice President of Reverentia that once Agnostica is again agrees to be bound by the provisions, the Reverentian engineers would reinstall the software. This now turns us to the second criterion, namely the temporary and reversible nature of the countermeasures. In the summer of 2013, as it is stated in the paragraph 13 of clarifications, the Reverentian engineers were again allowed to the mining facilities, and they in fact reinstalled the software, and the level of extraction of these facilities reached the level of 2011, which means that these countermeasures were completely reversible, they were completely temporary. As regards the proportionality criterion, which was argued, which was disputed by the applicant, the respondent would like to rely on the decision of in the air services arbitration, in which it was stated that in order to assess the proportionality, both cumulative and both quantitative and qualitative criteria should be taken into consideration. Which means that in order to assess the proportionality, the severe nature of the breach and the value of the principle which was in breach should be taken into consideration in comparison with the wrongfulness of the countermeasure.
But what happened in your case?
In our case, right, the Agnostica violated the fundamentals of human right, of international law, the Pacta Sunt Servanda rule.
Okay, and what are the consequences of your countermeasure?
The consequences were that the operation of the facilities which rest in the territory of...
Which entailed what? It entailed... Didn't it deprive people who expected...
Not in any event, Your Excellency. The Agnosticans were not deprived of the access to the mining facilities. They did extract...
Admirals? What happened in between
the
removal of software and your coming back to...
Yeah, the East Agnostica seceded from the Agnostica, and then on
you removed software when?
On the 3rd April 2012. The next
when was
day,
the Merseyside Act adopted?
The Merseyside Control Act was adopted on 1st October 2012. In about 6 months.
So there were reasons for this act, right?
Actually, there were not. And this was also the violation of the Merside Convention. Under Article 6, the Agnostica was under obligation to reveal and revoke any duties or barriers which could affect the transfer of Merside to Reverentia. And by enactment of the Merside Control Act, the free transfer of Merside was completely banned. It is stated in the paragraph 22 of the compromise.
And another question as to the temporary measures. Actually, did you, has your government called upon the applicants to negotiate the wrongfulness of their acts and their countermeasures? So was this the...
Well, you have...
Yeah, sure.
Yes. Please answer.
Yes, Your Excellency. The procedural requirements were also met in the present case. The first one is the call upon the other state to comply with the obligations was fulfilled prior to withdrawal of Agnostica from the Merside Convention, when the president of Reverentia declared the status quo, namely that the respondent objects to any possibility to terminate the Merside Convention. The second requirement is the ratification before the countermeasures should be taken into consideration can be neglected in the special circumstances, namely the urgent countermeasures. In the present case, the prior notification of
but you really do sound really positivist, right now. However, according to the complaint, it seems that basically all this medical use of Merside, would not be, if I can say, implemented because you remove the software, operations stopped, extractions of Merside stopped. As a result, like lots of children and ill people were prevented from using this valuable.
Not just
Isn't
deprived.
it included
No.
in the proportionality criteria? Didn't you have to assess what impact it will have on the rate of people?
Your Excellency, the proportionality criterion was assessed due to the fact that the Agnostica violated the Pacta Sunt Servanda rule. And as regards the
Right, but
effect,
also those sick children violate the Pacta Sunt Servanda rule. Why did they have to suffer?
Your Excellency, there is no indication that they indeed suffered. Moreover, there is indication that the supply of Merside to the international pharmaceutical companies continued. And moreover, what is most important...
But there was an interruption.
No, Your Excellency. After the removal of the software, the level of supply decreased. However, it did not stop. Moreover, the international pharmaceutical companies, which supposedly provided this resource to the children, also declared a moratorium on any purchase of Merside until the issue of the East Agnostica and its status and the status of Merside is established. So, Your Excellency, thank you.